Chanley Painter, glad we have you there to fill us in. And obviously, Chanley has her eye on what's happening at that appellate court, and will update us as soon as there's any news out of that. Now, let's switch gears and head to Florida. Jury selection in the Witchcraft murder trial in Pensacola just getting underway again this morning. Donald Hartung, Sr., is accused of killing his mother and two half-brothers in what investigators initially believed was a Wiccan ritual killing. An arrest affidavit claims that the elements of the crime loosely fit a Wiccan prosperity spell. Investigators then learned that Hartung had been written out of his mother's will and would stand to inherit all of her assets as the last remaining heir, with his family wiped out. Yesterday, attorneys from both sides took time to address prospective jurors about the role that law enforcement plays in this case.
Raise your hands if you watch CSI. Right, get them up. We know you all do. Okay. Will you all please acknowledge and agree that those shows are fiction? Okay, which means they are not true. They solve, the biggest of crimes all in an hour, including commercials. Okay, we don't want to be compared to those actors, and we don't want you to compare our evidence to your favorite episode of CSI. So everyone agree not to do that. Okay, very good.
All right, my legal panel still with me in studio, attorneys Lindsay Tatum and Travis Foreman. In New York, we now have criminal defense attorney Joseph Marrone, and also joining us in studio, Lieutenant Colonel Adam Lee, the assistant chief jailer. He is an assistant chief jailer and former chief of major crimes investigations in the city of Atlanta. I want to start with you, Adam. The case in Florida relies heavily on an informant, someone that investigators were able to talk to, who was incarcerated in the same area as the defendant. And some of the information is absolutely compelling. A lot of informant information just doesn't work, or is looked at through a jury, by a jury as problematic. In your experience, the whole informant world and the world of the jail, there are a lot of people in jail that will say anything they can to get a better deal, a different deal. Is it inherently problematic to rely on an informant?
For sure. I mean, you're dealing with someone who already has a criminal charge against them, and you have to be concerned about whether or not it's just self-preservation and they're making these things up. Usually what happens is you'll look at what they're saying and compare it to what you know. And if the two of them go together, if they're saying things that they couldn't possibly have known outside of not being a part of the crime, then that goes a long way in proving that their statements may be true and they may be credible.
And we may see that in this case. This informant had information that the general public couldn't have known on some level, and also provided some information that could be backed up by physical evidence. Let's take a look at some of the things that this informant informed investigators about with his conversations with Hartung. He told them that Hartung admitted to him that he tortured his mother to get a safe combination, and that he basically removed one of her fingers or broke one of her fingers. That obviously could be corroborated by the autopsy. A Ouija board gave Hartung the go-ahead to kill his family. Whether or not they found a Ouija board, that could be corroborated. And then Hartung disabled cameras inside the home. They had some sort of surveillance system, and sure enough, that surveillance system presumably was disabled. Another few items: a silencer used on the gun to kill Richard Smith. That was not something that was brought out. A local Wiccan priest helped Hartung allegedly hide evidence, and that he piled clothes on the bodies to mislead police on the time of death. Clothes were found on those bodies. So, Lindsay, when you look at that, maybe this snitch, whatever you want to call him, informant, could hold some weight.
Yeah, he could. I mean, it's one thing to just have information that you feel is valid, but then when the evidence backs up the statements, and these are statements that the world is unaware of, it just really, as a criminal defense attorney, makes me nervous, just to be honest, because it's kind of just like, oh, this is not good. This person is going to come in here, and I would love to attack their credibility, but then the state's just going to present evidence that literally validates everything that they're saying. And it's just not a great spot to be in as a criminal defense attorney. And this is probably going to be one of the most credible witnesses. I mean, depending now, all this depends on how he presents in court. Of course, that's still, something to be said about that. But, this might be one of the better and more credible witnesses, informants that I've seen.
So, Joseph Marrone, first off, welcome. But also, how do you then, as a defense attorney, attack somebody who's on the stand, probably in prison garb, but it's got a pretty compelling story?
Well, I mean, you always go and attack his credibility. I mean, pre-existing, is he a liar? Has he been convicted of crimes that constitute lying? Is there any conflicting information that he has given? And then ultimately, what's his motivation? What is he getting out of it? Is he looking for a reduced sentence? If he's in there for 20, 30 years and he's been promised something of a much reduced sentence, obviously he has a motivation to lie. Things like that don't sit well with jurors, and jurors really kind of look at that and closely scrutinize that. And that may be the case here. The only problem is there's a lot of corroborating physical evidence that matches up. And there's other evidence in the case, other witnesses that are pretty detrimental from what I remember in this case.
Absolutely. And Travis, that's a real issue for the defense here. Another issue is that the defense attorney and the defendant do not get along. Both asked the judge in this case to please let them separate because they're not in sync. For this defense attorney, if you were representing this client and you had this avalanche of evidence and you also had this dysfunctional relationship, how would you handle it? How do you proceed in front of the jury? Right now, you're in front of prospective jurors is different. Once this thing starts, either tomorrow or next Tuesday, it's time to button up.
Well, for me, either way, regardless of the evidence of what the informant has to say, when I go in the courtroom, I'm gonna try to defend my client as zealously and vigorously as I possibly can. That's our job.
Have you ever had a client that you didn't like and he didn't like you, and you both sort of coexisted?
Yes, I have recently, in fact. And it's your job. It's my job to provide a service for this defendant and to defend him and hopefully have an outcome that is favorable to him. And that's all I care about, regardless if I get along with that client or if he likes me or not. It really doesn't calculate into my defense.
Adam, the jail scenario of you as a skeptic, I'm always thinking that this was set up. That investigators threw this person in to get the information out of X, Y, and this person or this person. How does it work? If I'm a prosecutor and I want this inmate to be hanging with this inmate, do you facilitate that?
No, we would not prearrange that type of situation.
Have them meet,
like
or have them be in the same pod?
Plant an informant into the cell. No, we don't do that. And sometimes you find out information much later. I recently had a detective that formerly worked for me that is still active investigator in homicides call me in my present position to see if two inmates had ever been in the same cell together, because they were looking 2 years back. They were looking to see if these two guys were ever in the same cell, because now they're receiving information from this one inmate that this guy confessed to a murder. We were able to look back in the database, because we do keep those records, and we were able to show that those two guys were in a cell together on these particular dates. And so that sort of corroborated the evidence that they had, that they were actually together, and that he probably told him or confessed to him that he did that murder.
Joseph, you're a likable guy, so I'm sure you've never gone through this, but what would you do if your client hated you and you didn't like him either, or her?
Well, the problem is the number one issue is you're not going to be able to adequately defend your client, regardless if you have a working relationship or not. He has to be able to give you information and help you get along so you can defend him to the max. If you can't do that, you got to get out of the case. But when you're not on the same page and there's arguments, and obviously this guy looks like a train coming off the tracks right now. He's very desperate. Everything's mounting against him, and he's now disagreeing with his own counsel. If you don't trust your own counsel, at that point, it's time to separate. And know, and I've been in those situations, and the best thing to do is to file a motion, and hopefully the judge will let you out. I mean, the judge has to believe that there is no communication whatsoever and that you cannot fully defend this client. If he doesn't believe that, he's going to let you stay in the case because they need somebody to represent him.
And in this case, the judge had both parties asking, pleading, please, let us separate. But the judge said, no, you're not going to do this on the eve of trial. You've been together for years. You're sticking together through the next few weeks. All right, we're going to take a quick break here. Wiccan prayer rooms, prosperity spells. According to court documents, Donald Hartung lived, let's just say, less than a mainstream lifestyle. Coming up, a religion professor breaks down the Wiccan belief system and sheds some new light on this case. You're watching CourtTV Live. Stay with us. We're back to CourtTV. Jury selection in the Witchcraft murder trial is going on right now as we speak in Florida. According to court documents, the defendant, Donald Hartung, disclosed to police that he is a practicing Wiccan. Hartung's religion will probably come into play during this trial. A questionnaire passed out to prospective jurors specifically asked if members of the jury pool are familiar with Wicca. Our Seema Iyer spoke to an expert on paganism to get a little bit better idea of this belief system. Take a listen.
Contemporary paganism is kind of an umbrella term that includes a number of different traditions, and Wicca is the largest of those traditions. Contemporary paganism is a group of religious traditions that take inspiration from the pre-Christian, mostly European traditions. They are not institutional, and there is no specific doctrine that is required for people to believe. So therefore, there can be a wide variety of beliefs. However, some of the very common beliefs would include being polytheistic or pantheistic, being nature reverencing, honoring the divine feminine as well as divine masculine, and things such as belief frequently in reincarnation, the ability for people to continue to grow and evolve in their spiritual practice, as well as things such as belief in magic and belief in building appropriate, healthy relationships with spirits of a variety of types, including ancestors and nature spirits, as examples.
So when you talk about reincarnation, all these beliefs, you know, a lot of times people believe in things because of their religion. I believe in reincarnation because I'm a Hindu. But how does one get drawn to paganism and then specifically Wiccanism? Like, how do people follow it? Where do their followers come from? Who are these people?
So when you talk to people who are in the traditions, they come from a variety of different places. There are some who, because of their belief in reincarnation, would say that they find it based on prior experiences. There are a number of ways to find out about Wicca now. There's been a change since the 1990s where you began seeing things such as Wicca and paganism in contemporary culture. And of course, you have the rise of things like chain bookstores and then later Amazon, where you can find books and materials. The vast majority of people who are currently practicing are solitaries, meaning that they are not necessarily formally related to a group, but are coming to it from a variety of different explorations, often coming through the internet and coming in contact with other people.
Dr. Reese, did you get a look at this case involving Donald Hartung, and do you have an opinion of it?
So I got a look at it very early on, just very early on, around the time in which the sheriff gave his initial press release. And at that point, the way in which it was being framed was deeply problematic. And the framing of it was my concern at that time, because it was being framed as a Wiccan ritual sacrifice for the blue moon, which makes no sense given the actual religion.
Okay, and why is that? Could you just explain a little more? Because the blue moon, at least I checked, and it seems to be confirmed that there was a blue moon on July 31st, 2015, but the murders took place on July 28th, 2015.
Right. So there's a few different things. Most Wiccans follow their ritual calendar follows two different types of cycles. There's the solar cycles, which have to do with what they call the wheel of the year. And these are seasonal festivals that track the changes of nature through the seasons. And then there are the lunar rituals, which are the esbats, and these tend to be at the full and the new moon. But that's based on a lunar calendar. A blue moon is when a full moon occurs twice in a solar month. This never happens on a lunar calendar. The blue moon is utterly irrelevant as far as any kind of practice for the Wiccans' calendars.
Okay, is there something as a Wiccan ritual killing or prosperity killing?
No.
Okay, so these
No,
things go ahead.
Yeah, there is. Human sacrifice is not a part of any of the contemporary pagan traditions, including Wicca. In fact, neither is animal sacrifice. The kinds of offerings that are typically made to the gods and spirits by Wiccans would be things like incense and pouring libations, so pouring drinks, having shared communal meals that you give a part of your food to the gods or the spirits. These are the kinds of things that are part of Wiccan practice. It is not a part at all, nor is it a part of any of the contemporary pagan traditions.
And as you know, Donald Hartung allegedly has some type of pagan worship room in his house. Is his connection to paganism, Wiccanism, and this killing perhaps just coincidental?
It's possible. It would not be a part of the traditions at all.
Okay, so the bottom line is he cannot blame this killing on being a pagan or a Wiccan.
Absolutely not. Absolutely not.
Dr. Reese, thank you so much for your expertise. This conversation has been so enlightening. Our viewers truly appreciate it. Thank you.
My pleasure.
Okay, we know more about Wicca. My panel still here with me in studio, attorneys Lindsay Tatum and Travis Foreman, along with Assistant Chief Jailer Adam Lee, and in New York, criminal defense attorney Joseph Marrone. Joseph, to you first, how much of this witchcraftish, paganism, Wicca stuff would you want in if first you're the state, and then I'll ask about the defense?
Well, if you're your state, I don't think you really care one way or the other because there's a lot of physical evidence. Put aside this ritual business. There's physical evidence. There's outside witnesses that have him at the scene of the location where the murder was occurred. There's an individual that will testify, that his motivation was to get money from the estate, even though he wasn't in the will. There was physical evidence found in the property that were tools of the crime. There was a hammer in there. There were other weapons that match up. There was DNA on the property. So if I'm the state, I could care less. It's a red herring. So the question is, can the defense take this case and take this satanic ritual and spin it into their somehow the diminished capacity case? Can they show that this guy wasn't really acting in full capacity? This wasn't a premeditated murder? That's really the only angle the defense has. Based on what Dr. Reese says, obviously not. She says it doesn't coincide with the practices of this Wiccan type religion. I'm sure there's experts out there that'll say different because there's experts that'll go either way, provided obviously you can find them. But I don't think this whole business really matters at this point. I think it's totally irrelevant.
And Lindsay, but it's in the jury questionnaire. It seems like it's going to come in on some level because prospective jurors are being asked about it. Do you agree that could it be used by the defense somehow that because he's not following the rules of Wicca? Sorry, he's not following a lot of rules, murdering his family. But can you use it to maybe bring in at least, even look forward to the penalty phase? You hate to, wave the white flag, but frankly, if he thinks a Ouija board told him to kill his parents or his mom and his brothers, then there's something wrong with the guy.
Right. So, I think that there's so much strong physical evidence in this case that as a criminal defense attorney, sometimes you recognize that your best defense is really just to mitigate, everything that's going on. And so a way that the defense might be able to do that is to bring in things like the Ouija board telling him to kill his family, and also, this religion being sort of non-traditional and confusing, and maybe pointing him into different directions and capacity that might question his mental state if he's doing things that don't necessarily align with the actual traditions, so that you kind of are pushing towards, the penalty phase, because maybe you recognize that there's not really a lot that you can present to kind of undermine whatever the state is doing. And of course, we don't have an obligation to present any evidence as defense attorneys, but when you have so much compelling physical evidence in a case, it kind of makes you feel as though you want to do something or need to.
And Travis, it is going to come in because you've got the informant this was a thread within that, and the initial investigation was based on it. So if you're going to put an initial investigator on, if you're the defense on a cross, you're going to bring it up if you want to, would you?
I kind of see it both ways. I can see that I can understand Attorney Marrone's position that it's irrelevant, but I can also see how it can be valuable in a sentencing phase for the reasons Lindsay just spoke about. So for me personally, I would like to see more of a direct connection between the practices of the religion and the crime. I would like to see something, a diary entry or something where he's saying or that this religion is the reason he's going to take these actions. I just don't think the connection is strong enough, and that's why I believe it's kind of mostly irrelevant. With
the informant themselves or the investigators, Adam, from a law enforcement standpoint, they go to investigate this murder, this triple murder, and early on, it is apparent to them that this is a motivating factor. This is part of the case. They serve a search warrant on the defendant's home, and they find a prayer room. They have one step over another. There's a meal served to them. It all coincides. So this is the way they go. They hold a press conference. The sheriff holds a press conference down in Pensacola, telling people that this is part of the deal. Do sheriff departments sometimes push too far with narratives and show their cards that then later boxes in a district attorney at trial time? Because frankly, if they don't want this to come in, it's coming in because of the initial investigation.
Absolutely. There really should not have been any mentioning of that Wicca, what do you call it, Wicca? By the law enforcement and to the media. They should have held that close to the vest. The only persons or persons that should have known about that was the district attorney's office. You have to be careful about what you put out there because, as we were saying earlier, with the inmate that was in the cell with the guy, and there's information that he had, who knows? Now the police department has to go back and say, well, did we release that information? Did anybody ever say anything about her finger being missing or any of the other things that were involved that were evidentiary that may have been released mistakenly that someone could use to say, well, he told me he did this, but, well, the police said he did it. It's all out. It's everywhere.
Right, and you have an investigator that is cozy with the local reporter, or who is just frankly comfortable in his job and wants to tell everybody, "You're not going to believe this one." That we're investigating. It comes out, and it definitely came out in this case. I want to thank everybody: Lindsay Tatum, Travis Foreman, Joseph Marrone in New York, and Lieutenant Colonel Adam Lee. Thank you for your expertise. We're going to step aside and take a break.